Good afternoon, everyone. Welcome back to Business Law 2. Today we're going to be looking at Chapter 30, which is bankruptcy. And as part of the overall objectives for this chapter, first I would like for us to kind of understand a brief history of bankruptcy in the United States. We'll be looking at an overview of some of the provisions that bankruptcy provides for, as well as changes that have been made to the bankruptcy code. We'll be looking at the different types of bankruptcy. There's generally three main categories, and that's what we're going to be focusing in on. It's Chapter 7, Chapter 11, and Chapter 13, different forms of bankruptcy depending on your situation. And then lastly, we'll look at debtor's relief in terms of what's available outside the process of bankruptcy. So those are the overall kind of like objectives that we're going to be focusing in on in this chapter. The idea of bankruptcy itself, meaning that a debtor, and that could be individual or a different form of entity, so a business or maybe a nonprofit. The idea that if they become so indebted to the point where they're insolvent, meaning they're unable to pay their obligations, bankruptcy is available as a way to try and shed away and eliminate some, or maybe in some instances all of that debt. It depends on the type of debt. Some debt's not dischargeable in bankruptcy, and we'll talk about those examples in a little bit. Anyway, so it's grounded in the U.S. Constitution as a principle of federalism. If you remember, federalism is something that we discussed in Business Law 1 when we covered the constitutional chapter. Federalism allows states to grant you more rights than the federal government. It's just that the states cannot reduce your federal rights. So federal rights act as like a minimum or a floor in terms of rights that we have as just persons in our society. States can go above that and grant you more rights, which I'm going to talk about in the form of bankruptcy. Florida has done that, but they cannot go below that. So bankruptcy, as we'll see, you're allowed to have a certain amount of exemptions per asset category. So you're allowed to have so much in savings, so much in the form of like equity in your home, so much in the form of a car, furnishings, personal possessions, and so on. And if you are in excess of any of those categories, then it needs to be liquidated, and that's distributed among your creditors. That's part of being asked, that's the sacrifice you're being asked because you're seeking to have debt discharged officially in a court of law. Anyway, Florida, they have granted residents, and I'll talk about there's a strict kind of residency requirement in order to be able to declare this in bankruptcy. But Florida allows an unlimited amount of equity in your primary home or homestead, your residence, so that's untouchable by creditors in bankruptcy. So let's say I have a $1 million home that's paid off, and so it's all equity. I own a $1 million home, and let's say I owe $5 million to creditors, and I want to go bankrupt. So I go bankrupt, and the creditors would like to get a hold of my house. And in most other states, they would be able to attach a lien, or in some cases, compel me to liquidate my equity so that I can satisfy my obligations. But in Florida, that entire $1 million is protected, again, provided that is my homestead. If it's an investment property, if it's rental income, if it's something else, commercial real estate, that's different. That's not part of this. This only includes your primary residence. So what happens is Florida is kind of like a haven for people. If you know you're going to go bankrupt, this is like strategic bankruptcy advice that some attorneys will provide. Relocate to Florida, establish the residency requirements as per the bankruptcy code, and then pour all of your whatever assets you have, pour all of it into a home that's your primary residence, and then declare bankruptcy. After your bankruptcy is over, do what you want with your home. Then you can sell it, and then you have all that capital from that asset. So that's what some attorneys would advise for clients. Anyway, we'll talk about some of the particularities with that provision that Florida allows, but that's an example of federalism. States can grant you more rights than what the feds permit you. Jurisdiction over bankruptcy is exclusively in federal court, so if you are going to go bankrupt, that's not like a county courthouse thing. You have to go to the nearest federal courthouse to file your bankruptcy, and then that kind of initiates this whole process that we'll be detailing over the next 30 or 40 minutes or so in this video. So this is a slide, and I just like to try and show, like, in our nation's kind of recent history, so over the past like 40 years, we've seen a gradual uptick of cases where people are declaring bankruptcy. And so it's mainly on the consumer side where we have seen an increase or spike. Business bankruptcies remain fairly constant. As you can see, that's the green line, but the red line is for consumers. And you'll notice probably one thing that's very dramatic, and that's like between the '04 and the '08 years, so we're looking at about 2005, 2006, you'll see there's a sharp decline in bankruptcies. It's not that, all of a sudden, debtors decided to not go bankrupt. It's that in 2005, the bankruptcy code was changed that caused part of that spike that you see. And then after the change, a lot of people decided not to declare bankruptcy because they weren't really sure in terms of the fallout of what this new legislation was going to require. And so we'll talk about that in a few minutes. But it's just interesting how businesses remain fairly constant, but then consumer, bankruptcy has increased over time. In terms of the three general types of bankruptcy that we detail in this chapter and in this course, we have chapter 7, 11, and 13. 7 is usually what people think of when they think of bankruptcy, because that's liquidation. So all the debtor's assets are going to be liquidated to pay for debts. Any unpaid debts, unless there's exemptions, are going to be discharged then. So, let's say you have credit card debt, maybe you have a car loan, maybe you have a personal consumer loan. All of that stuff, is subject to being liquidated, and then that debt is discharged if it's deemed that you're not able to repay that because of insolvency. Chapter 11 is reorganization. And so this is usually in the context of a business environment. And that's where it allows a debtor to kind of reorganize and continue business operations. So this is where maybe you can renegotiate the terms of any of the debt obligations you have as a business. A lot of times, if creditors know that you're even going through bankruptcy, they'd rather take a cut, and get 50 cents on the dollar than force you into bankruptcy fully and then realize they're only going to get pennies on the dollar. So it definitely is kind of like a negotiating tactic that businesses could engage in as a way of trying to reduce their debt obligation. Chapter 13, this is individual debt readjustment, and that's what the reforms of 2005, that's what has ported a lot of consumer bankruptcies into. Essentially, every state has a state kind of median income. And if you are below that median income and you want to declare bankruptcy, you usually have the option of going through Chapter 7, which is the most beneficial for consumers. If you are above the state median income, so like let's say you still have your job, then this under the bankruptcy code of the changes from 2005, you're going to be required to go into Chapter 13, which is reorganization. What that means is that the debt that you do have, some of it may be discharged, but a lot of it is just going to get repackaged. And so maybe they'll lower the interest rate, they'll lower the principal a little bit, so you might have a partial discharge. And then they'll have a new payment schedule that's devised under the supervision of the court and the trustee in the bankruptcy process. And then you'll resume your payments after the bankruptcy is over. At some point, though, usually within 3 to 5 years, if there is any outstanding debt, then that gets discharged. The purpose of the '05 amendments to the bankruptcy code was to try and provide for some recovery on behalf of creditors, because as you saw in that chart, in the 80s and 90s, we just saw a continual uptick of cases of bankruptcy. And if consumers are going through Chapter 7, that's the most generous form of discharge. And so creditors have been trying to absorb a lot of those losses. And with the '05 amendments that President Bush was able to push through, that at least kind of reduces some of that burden of loss that creditors had to engage in. Regardless of the form of bankruptcy you enter into, if it's 7, it's 11, if it's 13, one of the advantages of entering into bankruptcy, and this benefits more consumers than I think business owners, is that for consumers, there's the automatic stay. And so what that means is any pending litigation or threats to litigate by, let's say, a creditor to the debtor ceases at that point. And so that provides a much needed kind of psychological break and relief for a lot of debtors, knowing that they don't have to worry about being called, they don't have to worry about receiving letters of collection and so on. All of that ceases once the formal case has been filed in bankruptcy court. Anyway, liquidation proceedings under Chapter 7 can be voluntary, which means debtor initiated, and that's how a lot of these cases do begin, but they can also be involuntary. Creditors, you might ask, why would they ever initiate the bankruptcy proceedings and on behalf of a debtor? And well, part of the concern is that if you have a variety of creditors and there's a large amount of debt that someone has, then it's part of, let's just settle this once and for all. Are you going to owe us anything or not? And if you're not going to owe us anything, let's officially write it off and charge it off, and then the case will just be closed then at that point. Sometimes creditors try and track debtors for years in hopes of trying to recover something, and after a certain point it just becomes not really practical to keep aggressively going after creditors, because you end up spending more money in some cases compared to what you could hope to recover by that particular debtor. And then that has created a whole aftermarket of debt transfer, and so a lot of creditors sell debt because they want to be done with it. And there are people that buy debt as just a way of maybe I can be able to squeeze some money out of this particular debtor. So anyway, for involuntary, that usually is commenced when there's 3 or more. If there's at least a dozen creditors, if 3 or more kind of come together, they file a petition with the court. And if the unsecured debt, remember, unsecured means that it's not tied to any asset, it's just tied to your credit worthiness, like a credit card. Then if it's over $13,475, then at that point you can kind of compel an involuntary bankruptcy proceeding. Under this slide at the very bottom, I do have that means test. Remember, I just mentioned in the previous slide, the means test is where that's going to determine if you're going to be going through Chapter 7 or Chapter 13. 13 is where creditors want you to go. 7 is where individuals prefer to go when they're going through bankruptcy. Anyway, rights of the trustee. So the trustee is elected by creditors. So that's the person that kind of oversees this process. So they work with the bankruptcy court, they work with the debtor. And the trustee acquires rights in the debtor property that is in excess of any allowed exemptions. I'll show you a slide in a few minutes of different categories of debt that you're allowed. And essentially the trustee has the ability to kind of seize some of those assets and sell them and then distribute the proceeds to creditors as part of the settling up process. Trustees do have specific rights in bankruptcy. If you don't like this as a consumer or as a business, then don't go bankrupt. You don't have to go through bankruptcy. Trustees can also void transfers that occur prior to entering into bankruptcy. Sometimes businesses as well as individuals make last-minute transfers of some of their assets. And it could be cash, it could be just anything of value. And the concern is that, are you trying to defraud the bankruptcy process by doing that? So there's 2 types of transfers that trustees are allowed to negate or void. First are preferential transfers, and so that's where you prefer one creditor over another. And if it's made within 90 days of filing, all of that stuff there's a paper trail. Trustees are able to review all this. And if they think that it is a preferential transfer that's not permissive, they can go to that creditor that you paid money to, and they can order that creditor to release the funds or whatever the asset was that was received to the bankruptcy court. And the ultimate goal is to distribute it equally among all the creditors. Some exceptions regarding preferential transfers, let's say that, in the couple of months leading up to the bankruptcy, you keep making your utility payments. You pay for your electricity, the water, sewer, garbage, as an individual or as a business, and you didn't pay your mortgage or you didn't pay your car note or whatever. I mean, obviously you're making a preference there, but that's in the ordinary course of business. And so we're not going to go to like the utilities and say, give us that money back. A trustee's not going to do that in that case. What they're looking for is if, you know, you have, let's say, a mortgage, you have a car loan, you have all these credit cards coming due, and let's say that, you know, you had like 10 grand in the bank and you paid your car off so that now you own your car free and clear. Well, that's a preferential payment. And so the trustee can easily get that money back and then distribute or divide that money up among all of the remaining creditors. Insider transfers, those are made within 12 months of filing, and it has the same effect. Obviously, trustees have the ability to negate those types of insider transfers, even when they occur. When we talk about priority of claims, you know, we talked about priority in the world of like secured creditors, and so there is some overlap here in terms of the world of secured creditors under Article 9, and then the world of creditors under the Bankruptcy Code. So a claim is a creditor's right of payment by a debtor, and so usually a proof of claim, it needs to be essential if you want to get in line, so to speak, as a creditor. And so whatever your proof of claim is, it could be the initial application, it could be the amount of credit that was floated, it could be any transfer payments, whatever it is. Then once it's recognized by the court, then we have to evaluate, well, who is in priority? Who gets first in line in terms of you know, getting stuff out of this debtor if there is stuff to be gotten. So claims are processed in bankruptcy on a basis of priority. So secured creditors, like we've discussed in the past, are always first. So if you have, you know, if you are a mortgage lender, and so you are, you know, the party to the mortgage that financed someone's house or building, if you financed the car that an individual or business has, or a fleet of vehicles, whatever it is, you know, you have, you know, kind of like priority because you have a claim on the title for that property, as well as the amount that's owed. So secured creditors always do well. Other priority claims, you know, orders for, like, let's say domestic support, administrative expenses for the bankruptcy itself, employee wages if you're dealing in a business environment, unpaid contributions to benefit programs, again, that's an employer-employee arrangement, consumer layaway, and then taxes owed to government, those also are priority parties. Unsecured creditors, you know, who file timely, and then unsecured who filed late, as well as miscellaneous claimants are at the bottom. And if you're at the bottom, you usually end up getting little, if anything, at that point. If you end up getting nothing out of bankruptcy as a creditor, then whatever balance is owed, you just charge that off at that point. Because, you know, once the bankruptcy court discharges that debt on the debtor side, then you have no other ability or recourse to go after the debtor. It's been closed at that point. So the exemptions in bankruptcy, as I talked about, Florida gives an unlimited amount of value if it's in your primary residence or your homestead, not investment property, not commercial real estate, not agriculture, like if you own, you know, like orchards and stuff. We're just talking about your primary residence. And so the length of time that you have to have owned that exempt homestead exempted property, so the length of time you have to be a Florida resident, is 1,215 days prior to bankruptcy filing. So I don't have a calculator in front of me, but, you know, if you divide 1,215 by 365, that's the number of days in a year. I think it ends up being like 3 or maybe 4 years roughly. I think it's more like 3. And so that's what you have to, you know, that's that duration you have to establish. So if you are going to try to kind of strategically go bankrupt, it takes a lot of planning in order to successfully implement it and then actually execute it. It's not like you just move here and then once you're a resident, you declare bankruptcy and you protect all of your assets. That's not the case. You've got to satisfy that 1,215-day requirement. Here are the categories, and these are based on an individual. And so if you're a married couple, obviously you would times these by 2. So you're allowed up to $3,775 in a motor vehicle. So if you have 2 people, then you double that. You're allowed to have up to $1,600 in jewelry. So again, if you're 2 people, you can double that. $12,625 aggregate value. when it comes to like household goods, tools, and other types of tools of the trade, books, health aids. That's an almost $2,400 allowance again per person. And then $12,625 in loan value, dividends, or interest in a life insurance policy. So again, these are individual amounts. If you're married, you can multiply these times 2. Now, in the world of, I've never practiced bankruptcy, as a specialty in the area of the law, but I've known individuals that have offered bankruptcy services as an attorney. And, one of the things, and this really depends on, individual, kind of like your perspectives as legal counsel. Let's say that you have, no car, but you have, let's say $2,000 in jewelry. And you're declaring bankruptcy as an individual. Well, anything over $1,600 is going to get pulled out of your jewelry, and it's going to get sold and divided up among your creditors. Some attorneys will advise you, well, self-liquidate so that you're down to $1,600. And then what was over $1,600, buy a used car with that's worth whatever that excess is, as long as it's under $3,775. So, even though some attorneys have an issue with it, there are other attorneys that have no problem with just, shifting your assets around so that you can maximize each category. Otherwise, if you don't want to do that, then, if you have an excess in one category and you have nothing in another category, that excess gets taken, sold off, spread among your creditors, and that's just it. So that's something that you have to figure out with the advice of your legal counsel. Other exemptions under Florida law, and a lot of these are common in many states across the United States. So if you have like an IRA, if you are part of an established pension or retirement system for the state that you live in, so like Florida has a Florida retirement system if you're a public employee, firefighter pensions, police pensions, teacher retirement benefits, those are all examples of other things that are protected in bankruptcy. So, the states do try and look out in unique ways for its residents, so that, it's not like, if you are going bankrupt, you're going to have all these assets stripped away from you and all that you've kind of worked towards. But again, the theory of bankruptcy, the idea is that, we want to try and protect people so that, if life happens, something unexpected happens, there are mechanisms in place that will protect you and what you've worked towards. Discharge in bankruptcy, this is the decree that terminates the bankruptcy proceeding and generally kind of releases the debtor from whatever is listed as part of that discharge order. So, maybe, it's credit cards, it's, other type of consumer loans, business loans, depending on if you're individual versus a business bankruptcy proceeding. There are some things, though, that are exempt from discharge. Income taxes, and that's state and federal. The state, like government is always going to get its cut, so there's no way around that. You're not going to discharge tax obligations. You might get the government to settle for a lower amount just so that it clears the account. But the idea of going bankrupt so that you can wipe out your tax debt, that's not going to happen. Child support, student loans, at least in theory, student loans can be discharged. In reality, they usually are not in almost every case. I have read of some cases involving student loans where there was a one particular case where the person was a quadriplegic. They got into a bad car accident, and so they were paralyzed from the neck down. And the bankruptcy judge in that case said that, to the debtor, well, I mean, you still have your mind, you still can talk, you still can see and hear, so you probably can do some kind of work, and because of that, you can still pay your student loans. So, fairly kind of heavy-handed or kind of coming down pretty hard on that particular debtor. But the theory is that you can discharge it, but in all practicality, it's not. Loans obtained by fraud, alimony, judgments based on willful or malicious injury. So all of those are examples of things that you cannot discharge in bankruptcy. Denial of discharge can occur. So, this is a legal proceeding that is kind of opened up and usually initiated by the debtor, but we know that creditors can initiate it, that voluntary versus involuntary petition. And in the course of the proceedings, any one of these things that pop up can just act as an automatic denial of discharge. So, within a year of filing the petition, if you conceal property or if you try to, fraudulently transfer stuff and it's discovered, and it usually does get discovered. I mean, a lot of this stuff has a paper trail. If you fail to maintain proper financial records, so I mean, like you didn't even try, I mean, it's one thing to just not be very well organized, but to have like no records or to be extremely careless. A court will just say, if you don't have your financial affairs in order, it's not our job to do that. So the case just gets dismissed, not discharged, dismissed. If you made some sort of false oath or account, if you failed to explain for a loss of assets, maybe 6 months ago you had $20,000 in the bank and today you have none. And if you're asked what happened to it and you're like, I don't know, I spent it, it's like, well, that's definitely bad faith. You got to be able to account for everything. And so if you cannot do that, the case can just get dismissed at that point. If you obtained a discharge within the last 8 years, so normally, bankruptcy, you've got to go at least, 9 years or 10 or more sometimes before you can declare bankruptcy again. You can't declare bankruptcy today and then go through it again in 1 year. It's not designed to be abused in that way. If you filed for a written waiver of discharge that is approved by the court, or for consumers, if you failed to complete a personal financial management course, that's one other thing that the 2005 amendment requires, is that in addition to try and nudge debtors into Chapter 13 bankruptcy, it also requires, it requires individuals to seek financial management counseling. And the goal is, again, if sometimes people just don't manage money very well because they were never taught how to do that. And so the financial management course that's required now under the bankruptcy code tries to give individuals and maybe business owners the tools necessary so that they don't end up in the same debt trap. Because, at the end of the day, everybody, all that we want is for you to pay your bills like you promised you were going to do. That's it. And so, if you have some sort of deficiency, if you don't manage money very well, maybe a financial management course can help you in that regard. So anyway, that's bankruptcy in a very quick nutshell. If you have specific questions, please, as always, feel free to contact me. You can email me, you can call me, you can text me, whatever is easier, and I'll be more than happy to get back with you as soon as I can. But have a very good, safe, and productive rest of the day and week. Thank you so much.